Okay. Good morning. Are we live?
Press your button.
Do I need to press my button?
Nope, you're good.
Okay. Good morning, ladies and gentlemen. Everyone, thank y'all so much for being here this morning. What a great crowd. Um, uh, I really appreciate everybody being out here on a Wednesday morning at 10 o'clock. And I know traffic was fierce out there. Welcome to the House Study Committee on Affordability and Accessibility of Georgia's Legitimation Process. Before we get started, I'm going to ask our esteemed Vice Chairman here to lead us off with the invocation.
Thank you, Mr. Chairman. And before I do that, Mr. Chairman, I just want to thank you for your leadership on this committee and what you're doing for the state of Georgia and for fathers around this state. I think is quite fitting and timing that we study this issue and look into it from a bipartisan perspective. I'm very, very excited about the pre-work that we've done and the information that we've gathered and the more things that we're going to learn. And I think it's equally important, too, that we also say thank you to Speaker Burns for allowing us the opportunity to conduct this study committee, because as you know, every study committee is formed at his wishes and his request. And so we appreciate the speaker for his leadership. And with that, if you will, please bow your heads and join me in a quick word of prayer. Dear Heavenly Father, we want to thank you first for waking us all up this morning, God, giving us another day to be effective in our communities, in our cities, and in our states. Lord, we want to thank you for protecting us as we traveled to this location to do this important work that we are doing here today. And God, as we're doing this work today, we ask that you cover us in our minds and that you guide us in our thoughts and that you lead us in our words so that we may say what's your will here today and do what you feel needs to be done for fathers, for families, for children, for this process around the state of Georgia. Lord, we thank you for blessing our great state. We thank you for the leadership of our state, Lord, and we thank you for continuing to guide us and just place every step that we take one foot before the other. And we know this all you and nothing but you, because you say, look to the hills for which cometh all of our help. Lord, we ask that when this meeting is over, you allow sound minds to continue to deliberate on the issue and come together with terms that would be great for us to move forward. And we ask that you bless us all with safe travels back to our final destination and that we continue to do the great work of this state and the people of Georgia. In your name we pray. Amen.
Thank you, Mr. Vice Chairman. Before we get started, I'd like for the rest of our committee members to introduce themselves, tell us a little bit about who you are and where you're from. Mr. Vice Chairman, you may want to add something to that.
Absolutely. Yes, Representative Teddy Reese, House District 140, Columbus, Georgia. The heart of Columbus. I cover pretty much our downtown district, the business district, from one of our major highways, J.R. Allen Expressway, down to Fort Moore, Fort Benning, which is a part of my district as well. And it's an honor to be here. Thank you.
Representative Hefner.
Thank you so much, Mr. Chairman. My mic on.
Sorry.
Thank you, sir. Appreciate that. Thank you, Mr. Chairman, and to Vice Chair Reese and to my colleagues who are interested in this very, very important issue. I am State Representative Lynn Hefner, and I represent the finest city in Georgia, Augusta, Georgia. Where my delegation represents Augusta National and the home of many other greats like James Brown and some of the great, the fine educational institutions, Augusta University and Georgia's very own HBCU, Payne College. I am particularly interested in this segment and this study, and I would piggyback on my colleague in the adoration of the speaker for having the heart and the mindset to spend some time on this particular subject as it relates to our state. But my background is military, and so I represent the district that also encompasses Fort Eisenhower, which is formerly Fort Gordon, and the home of all of the military cyber excellence. So my concern specifically as it relates to this, well, I shouldn't say specifically, but particularly because of my background, is how this issue impacts those who protect and serve and defend our country. as they are scattered abroad on many occasions, they do not have the opportunity to exercise their rights in terms of fatherhood, but they are required by the Uniform Code of Military Justice to make sure that their obligations are met. I have 4 sons, and one of them is one that is currently serving in the United States Navy. And he is in this situation where he is a father who has a child who does not live with him. While he shares an experience of joint custody, that is indeed fragile. So where those concerns are, I have particular interests. I understand the narrative, and I am very, very proud and honored to be a part of this conversation and to participate today. Thank you very much.
Thank you, Representative. Representative Vance Smith.
Thank you, Mr. Chairman and Vice Chair. Appreciate y'all having me on the committee. Nice being here with Representative Lynn Hefner. I represent West Central Georgia, District 138. My home county is Harris. I represent about 80% of it, a portion of northwestern Muskogee, which is Columbus, and I go all the way through Troup County up to Heard County. So I follow the Chattahoochee River, more of a rural district than not, and happy to be on this subcommittee and look forward to working with y'all. Thank you.
Thank you, sir. And we also have Representative Rob Clifton from Augusta, who's watching online today. He couldn't make it to Atlanta this morning because he had other prior engagements, previous engagements. He doesn't know he's on the committee, and he's not really, but our adjunct member is always the inimitable Stan Gunter, who's chairman of our Judiciary Committee, who's always been a great help and ally and resource and a mentor to me since I got here. But we're going to jump right in. Today at 11 o'clock, the Speaker of the House, there's going to be a prayer vigil at the Capitol on the South Steps, and everyone's invited we're going to take a little recess and walk over to the Capitol to the South Steps. So we're going to move really quickly today. Substance over form. Our objective on the study committee is to really study this issue and hear from Georgians across the state involved in the legitimation process. Our goal is to put together good recommendations for the General Assembly to consider during our next legislative session. The plan is we're going to be having at least 3 meetings this summer, with today being the first. Our next meeting will be in Columbus, where 2 of our committee members live, our Vice Chairman and Representative Vance Smith, on August the 13th. And our third meeting will be over in Augusta, where Representative Rob Clifton and Representative Lynn Hefner live, and they're going to be hosting us over there. So we're trying to get around the state, and we're trying to get as many people involved as possible. Our goal for the meeting today is to help our committee members to get an overview of the issue. And we have some very experienced subject matter experts with us today that will really help us understand a little bit about the history of the legislation, where we are today, and we'll hear some different perspectives on what works well and what we could possibly do better. Most importantly in this meeting, the other people in this room and in our subsequent meetings, we want to hear from the folks all over Georgia that have been affected by the issue. So without further ado, we're going to jump right into our sort of subject matter experts. And we'd like for each of you who are going to speak to just introduce yourselves, tell us who you are, and sort of a little bit about your background, and then take it and then tell us what we need to know.
Thank you, Chairman Barrett, and thank you to the committee. My name is Katie Connell. I practice family law here in the Metro Atlanta area, although just yesterday I was down in Middle Georgia. So really, I'm all over the state practicing family law. I'm in my 20th year of practice, and all the things that come with family law, which of course includes legitimation, custody disputes, whether the parties were married or not, the follow-up actions that very often come, contempts and that sort of thing, modifications of custody. And for many, many years, I should have done the math, Chairman Barrett, because you've asked me before. I've been on the Georgia Child Support Commission. And so as a member of that commission, I have heard lots and lots of testimony and comments from the public about this legitimation issue. And of course, we're, always focused on Georgia's children in that role. It's just that obviously from the child support perspective, we're focused on the money, but there's always a best interest factor to consider. And I thank you for having me here, and look forward to talking to y'all a little bit more about legitimation in Georgia.
Good morning, Mr. Chairman, members of the committee. I'm here, Regina Quick, here at the request of Katie Cannell this morning in my capacity as a recovering family lawyer. But I also currently serve as General Counsel and Deputy Commissioner for the Department of Human Services. And that, of course, includes our Division of Child Support Services. We are affected somewhat by this issue, and I can explain that as we move forward. But I'm not here representing the department today. Katie and I serve together on the Georgia Child Support Commission, and so I hope I can also lend some color commentary if it's needed for the repeal of administrative legitimation, since I served as a representative representing Athens and 3 surrounding counties during the time it was repealed, and was somewhat of a participant in that process. So I'm here to try to help answer any questions the committee might have about the legislative history of that as you move forward to try to find a solution that works better.
Good morning. My name is Carrington Buzz. I'm the postgraduate fellow at the Barton Center, Barton Child Law and Policy Center. I'm here as a representative of Barton just to talk about the legal aspect of legitimation. Barton has served, I think, for over 25 years as a resource to the state of Georgia, and here to act in that role. Thanks.
Thank you. Thank you for being here today. So take it away, ladies. We'll start with y'all, and then we'll move to Mrs. Buzz, so take it away. Tell us what we need to know. Talk to me like you're talking to a 12-year-old. Assume for everybody in this room that we don't know this issue backwards and forwards. And I think that's a good thing, because the issue is such a profound issue, and so many people who get to deal with this on a personal level have never even heard of it as well. So please take it away.
Sure. Thank you, Chairman. So, in preparing for today, I wanted to, and I'm happy to receive redirection or questions from the committee. I'm not one of those people that needs to finish. Please engage with me. If something I say sparks a question, just ask. But I thought, if I understood my directions from the chairman, that I would start by giving y'all a little bit of background and information. So with that, I'm going to recommend to you, and I apologize, Mr. Chairman, that I didn't do this sooner, but it literally occurred to me last night, a resource for the committee. That it will be very short, but will give y'all nice background. There is a podcast that is sponsored through University of Georgia's Law School, which is not where I went to school, so I'm not plugging them. But the Judicial Education Commission has 2 judges. Well, I guess they're now, one's a former judge, retired, and one's now moved his way up out of the Superior Court. Judges Paget and Tain Kell out of Cobb County. Judge Paget's from Augusta. They do a podcast called The Good Judge Meant, not one word, so the judge ends up with the E, podcast. They've been doing it since, I don't know, don't quote me on this, maybe 2019. Episode 66, which is a 2021 episode. Easy to get to, y'all. You can just go on your app, find it. Their podcast on legitimation. It's about 40 minutes long. It was in 2021, so there have been a few amendments to the statute since then, but I've listened to it recently to double check it, and none of the amendments that have been made since they recorded the podcast impact what they say in the podcast. So I think it's just an easy resource for y'all to, again, go and get a little bit more background, learn a little bit in an easy way. It's very conversational. Remember that those judges in their podcast are their podcast target audience is other Superior Court judges in Georgia who want training on different issues. So it's an easy peasy. They also have a website where they put some written materials. So that's an easy way for the committee to get a little extra information from a different source with really no alternative political agenda in any way, which I would think the committee might find refreshing. They also mention, as Ms. Quick just referenced, they make a reference to the 2016 timeframe when Georgia did have administrative legitimation, and unequivocally say it was a disaster. And that's just the perspective of 2 Superior Court judges who were dealing with it. And I know we'll talk to you about that a little bit more. As we sit here today, just by way of background to the committee, legitimation in Georgia is currently governed under Title 19. Really, it starts at 19-720. and goes through 24, 25, 26. But really the thrust of it is in 19,722. And that's what sort of currently governs what we're talking about more than anything. And there are, of course, some cross references to the other subsections there. At this point, in my humble opinion, legitimation in Georgia is entirely too difficult, too complicated, too cumbersome for Georgians, for the children who are not getting the benefits they deserve, and for the parents who want to establish their role and rights with their children, and they're effectively being treated differently than the parents and or the children who are having children in wedlock. Just for reference to the impact on this, I pulled from the CDC website and I brought extra copies for the committee. Their information goes as far as 2022, but this is a state by state stats on children born out of wedlock across the United States right now. And Georgia is not in the highest bracket in terms of percentages, but we are right on up there. And this is in 2022 and the stats are trending up. So, I mean, I can't verify that personally, but I can tell you that if in 2022 we were falling in that 45 +% of children being born out of wedlock, it's almost certainly more now here in 2025. So in 2022, it was up around 45%. So we are in the second highest level across the country in the way that they bracketed it out. So this is just, this is just by percentages. So this is a real issue and it's affecting many, many Georgians. And of course, it's not just their parents that are affected, it's the children themselves. So I think I commend you all for doing this work because it clearly needs to be done. A couple of things to note at this point, just maybe technicalities, but worth considering. As of right now, Georgia has two entirely different statutes that address paternity and legitimation. They are two different animals in our code section. Now, very often they end up together in one lawsuit and go hand in hand. But right now it falls under two different code sections and they are done separately. Only a father can file a legitimation action. And he has to bring the biological father or the putative father or reputed father has to bring that legal action against the mother. For a long time, so we have made some improvements. It's not all doom and gloom. For a long time, a separate action needed to be filed after the legitimation action for that father to secure any parenting time, visitation, or custody rights. We did amend the statute a number of years ago so that in that legitimation suit, he can seek parenting time. So we've made it slightly less cumbersome that it doesn't have to be a second lawsuit, but it still requires a full lawsuit. Whereas any child born to the mother is deemed the legal child of that mother upon the child's birth. If the parties are married at the time of the birth, it doesn't matter that they weren't married at the time of conception. There is a presumption, rebuttable, but a presumption that those two parents, the married people, are the parents of that child. Now that gets complicated because that's not always accurate from a biological perspective. I have had cases in my family law practice, and we have had cases across Georgia where there was a child was born in wedlock, which our code 19,722 deems the rebuttable presumption that that child is as a product of the marriage, is therefore the legal parents are the mother and the father, the husband of the mother. But there are times when it turns out that father is not, the husband is not the biological father of the child. And then you end up with lawsuits to address the legitimation of the child, the parentage of the child, the paternity of the child. I talked to a colleague the other day and asked her about just some anecdotal, I wanted to give you all some anecdotal examples of where these things get complicated. And she was telling me about a case she had where she became pregnant, had the baby, but by the time the child was born, she and the biological father had broken up, were no longer in a relationship, never were married, and she was in another relationship, but a committed relationship. So that man number two, was present for the birth, signed the birth certificate. They both said, yes, he's the father, and they go on about their business, but don't get married. Don't file legitimation action. So this child does not have a legal father. A couple of years later, that relationship with man number two, who is putting out there that he's the father of this child, the child believes he's the father. That's the story that everyone's hearing. They break up, mom and man number two. That guy then says, oh, well, I need to legitimate this child. I believe he's mine, and I don't want to lose this relationship that I have with this child. You know, everybody can see a scenario where that would make sense. So he goes to do that, and then she says, au contraire, you're not the father. So she gets in contact with biological father and says, you're actually the father of this baby. Then he says, well, hold on. Okay, I do want to participate. So then the case is before a Superior Court judge who's looking at biological father and saying, you know, I don't know what to do with you. I don't know. You know, it becomes complicated. We've got a guy who's been acting as father, financially supporting the child, participating in the child's life, a guy who's actually the biological father who now wants to participate. The mother ended up marrying the biological father essentially to create the legal relationship for the biological father, because the statute says that even if they get married later, if they both claim the child as his, you know, and he actually did have biology, so they didn't get married to stay married. They didn't get married to raise the child together. They didn't get married for any of the other reasons. I mean, we hear about people getting married for nefarious reasons. I don't know if I'd call this one nefarious or not. I guess maybe that's a little too much judgment, but she ended up marrying biological father in order to sort of excommunicate the man who had been helping raise the child. I just give that as an example of how it can be very complicated and not so easy, cut and dry. It's easy to sit back and say, well, let's only rely on biology, or let's only rely on this, or let's make it easy. It's not easy. And so I would just encourage and caution the committee to really look out for unintended consequences, and remember that every anecdotal story you hear, where it might be easy to find a winner, or someone you really want to back in that story, there's going to be another story where that rule that you were thinking of that would apply to this scenario might really hurt someone in a different scenario, and you would say, well, that's not how I want to do it in this scenario. And that's the thing that gets really tricky. Regina, do you want to weigh in there?
Yeah, I do think this dichotomy, though, between biological father and legal father that exists in Georgia law does create problems, very, very significant problems. And so that is, while biology may not be the end all be all determinant as you look at a statute, it does need to be in the statute in a way that it is not currently. And I'll just, again, I'm not here on behalf of the department, but I will tell you that for our Division of Child Support Services, when we are mandated from a federal and state standpoint to establish a child support order, we do that by first establishing paternity. And so it is a very difficult position for our people to then be in when that biological father who is about to be ordered to pay child support says, well, I'm not being allowed to see my child. And we have to say, we cannot help you. This child is not legitimate. And so you must hire a lawyer and you must file under 19722. And I think most experts will tell you that seeing a child and having a relationship with a child is a very strong indicator that somebody's going to pay their child support more regularly and readily. And so that focus on biology, while it might not be an end-all be-all, as Katie has explained in the anecdotal story, it does need to be recognized in a way it currently isn't.
And I agree with that completely. I do think that we need to address the biology and make the process less cumbersome for those parents who are biologically connected to their children and asking to be a part of their children's lives. It's too hard.
Thank you, Regina. I think you just said something of great significance, that we do lack the biological part right now in our statute. But as we move forward, I'm very interested in this committee not making the same mistakes that we've done in the past, because I don't think many of us, Vance may have been around in 2016, but can you talk about You were just born in 2010. Can you talk real briefly, if you don't mind, what went wrong? And I'm sure it was some good intent with that legislation, but where did it find its greatest hurdles? And how can we prevent those hurdles, or at least find a compromise you think that may make that work? Or do you think, in your perspective, that we should just take a different route? Because as I sit here today, I mean, 15 minutes into this hearing, I'm sitting here thinking to myself, there should be some type of biological component. And then you said it. And I was like, well, bingo, and Katie touched on it a little bit. But where did we go wrong in 2016, and how do we avoid that in 2026?
So this is a complicated topic that people really care about, and so part of dealing with it, as you'll see when you get involved in it and you actually drop legislation, is there are a lot of people going to be interested in this. But where I wasn't around, obviously, when administrative legitimation was enacted, I believe that was 2005, but I could be wrong about that, 2005. 2006. Where that came from, as I understood it, was there was an effort by the federal government and otherwise to make establishing paternity a little simpler. And so they developed this administrative process that folks did at the hospital to what could possibly go wrong, right? At the hospital to acknowledge paternity. And also, when that legislation was passed, there was a companion piece of that to allow the acknowledgement of legitimation. And as you've already heard, that created quite a different legal status. The difference between paternity, where the biological father says, I'm the biological father and I'm going to acknowledge that I'm the father of the child, versus both mother and father have a role in consenting to, at that point, a legitimation, or saying, I'm going to be the legitimate father of the child. And it deals with this this difference in not having the right to see the child and there not being a court order in place. If you just say the child is legitimate and therefore the father can visit or have custodial rights to the child, you don't have a court order in place to further define those rights. And so you don't know, does that mean joint legal custody? Does that mean mom has sole physical custody? Does that mean there's a visitation schedule? If so, what is it? So
Let me ask you this, because if a child is born out of marriage, like my daughter right now, my 8-year-old daughter, I don't need a judge's order to tell me when I can see my daughter. And I don't need a judge's order to tell me I can go to the school and check on her grades. And I don't need a judge's order to tell me that I can go to the hospital and inquire about her health condition in the event that there's an emergency. If a child has been legitimized, and we've done the legitimacy process at the early stages, why is there still a need for a parenting schedule if that father is deemed the father of that child? Why are we not extending the rights of a married father if is indeed 100% legitimate?
So I think that goes to these unintended consequences that you'll have to struggle with, and that is that those folks may not be living together. And so that may necessitate the need for some sort of schedule. But what went wrong with administrative legitimation was, first of all, nobody knew how to find the form 3 years later when somebody said, we signed something at the hospital. And so it was creating a real mess in juvenile court for the juvenile court judges to try to figure out whose rights are we terminating at that point, or who's even supposed to get notice that the state has stepped in to try to protect this child and take custody. And it was creating problems for adoption lawyers who couldn't figure out what process they were supposed to follow. Was this child legitimate or not? So whatever they described in the podcast, I'm sure was mild compared to what judges and practitioners were experiencing for a lengthy period of time. That's what led up to the repeal of administrative legitimation. But those are the issues that have to be wrestled with if you say biology, just for shortcut here in trying to answer your question, if you say that biology equals equals legitimation, you still may have to have some type of schedule that a court orders or interjects to put in place. But at least at that point, the parents will be on equal footing.
Right.
And there's
Right.
no presumption one way or another about custody or anything of that nature.
And Representative Smith has a quick question, but just for my closeout follow-up. We also initiate birth certificates at the hospitals, right? And they find their ways to the legal organ or the legal process to where it's a government kept. Somehow they're getting there safely for the most part. I haven't heard of any large scale issue with birth certificates, and sometimes death certificates are issued at the hospital when they find it. So why can't this form find its way to a legal entity that will be the keeper of the records, whether that's Superior Court or Vital Records or whoever it may be? It seems like it should just be able to tag along with a birth certificate.
And Katie may be able to shed some more light on this. I think she's about to say something, but that was part of the legislative fix in 2016 as to the paternity acknowledgement, to try to put some things in place so that that form was more readily available and kept in the regular course of the hospital's business. But
So a couple of things. The anecdote that I told you guys about a few minutes ago, the man that was at the hospital when the child was born signed that form. And he was the 1 in a million who kept a copy of it. So he was the legal father. He had signed the form, but he was not the biological father of that child.
Biology was not done at the time.
Not even considered. And the mother at the time when the child was born, the mother's in the hospital having a baby. This man is with her and they are both saying, this is our baby. And when paperwork needed to be filled out, both of their names were put on it, birth certificate and administrative legitimation form. But it was not biologically that man's baby.
So biology would have told us you're not the father, and biology would have prevented us from allowing him to sign that form as the father, especially being acknowledged legitimacy rights when you're not the biological father.
Well, yes, but the rub is that when biological father was notified and came in, he was like a second-class citizen in the lawsuit because the child at that point under the law had a legal mother and a legal father.
Okay, I know.
Let me.
Well, let's follow. If you're not the biological father, then that's an adoption. You can't. I just don't see how you could legitimize a child that's not biologically yours.
It happens all the time.
Let me ask this. When children are born, don't they do a DNA or blood test or anything? Why wouldn't they do that to know that that is the dad and this is the mother and this is the child of these two people? Well, it looks like that would clear a lot of stuff up.
Well, I have 2 children. I have the pleasure of having been married for 19 years to this point, and a DNA test. If you had asked me and my husband to do a DNA test when we had our children, I would have said, who's paying for that? Why would we do that? I don't need that. I know it's my child. My husband knows it's his child. We're in agreement, and you're infringing on our rights if you think I'm going to take a DNA test to prove that this child that we both agree is our child and we have no dispute.
But wouldn't it have cleared up that the scenario you gave us about the man that said this was my child and it wasn't his child?
Sure. But at the time that that child was born, there were 2 people standing there saying, we are so happy that our baby is entering the world and it is our child and we are representing together that it is our child.
Make sure we're comparing apples and apples and oranges and oranges. In your scenario, you said you and your husband,
That's right.
you all were married, so you already had the protection of the law. In your fact pattern, they were not married.
That's right.
Which is a red flag, which should be the indicator for some type of biological test if the person is not married. If you are married, we're not going to force you. I mean, I would have been insulted. Someone would ask me to take a blood test with Captain.
So let me suggest this to you. Circling back to your very first question, you referenced your own daughter, as I have now just referenced my children. Nobody has to tell you. You don't need a legal document to go pick her up at school. So I routinely tell my clients when I'm counseling them through the divorce process that for the first time, we are going to have paperwork that gives them the rights to do things like go to the school, talk to the doctors, take them to the hospital when they need stitches. that they didn't need when they were a married couple. But now they are going to need it because they're divorced, and Georgia requires a parenting plan for children who are the product of divorce. To your point, Representative Reese, there are sometimes different standards when life circumstances change. I don't know if the solution is to make every child born out of wedlock submit to a paternity test in the hospital. I can imagine a lot of problems with that, including the expense. And I'm not a constitutional lawyer, but I can imagine some constitutional issues there as well. But that's just an example of why the administrative legitimation, as well intended as it was not the right fix. And it was bad.
Maria, could you give us some insight on would a blood test at birth be cheaper than trying to pay a lawyer to go through the legitimation process for a father?
I have no idea how much a blood test in the hospital costs. I can't imagine it's not less expensive than hiring a lawyer, but that is outside my wheelhouse.
I think our vice chairman's touching on an important issue that's certainly worth something to consider as we go through this process as something in the discussion about possible remedies or ways to improve on the legislation. I'd like to also open this up to Mrs. Buzz and also Alexis Putt from the Seaman Law Firm. She's a subject matter expert with a lot of experience as well. I want to open this up to y'all as well, just because of the sort of back and forth that we're doing here. So why don't you weigh in for us?
Try and make this quick for you all. So again, I'm from the Barton Center, but I do want to say that the views expressed are from my experience and research, do not express the opinion of they reflect the position of my employer. I think I may hit on some of the questions that were asked regarding like how we got here legally. But really the theme here is like, who is a parent and why does it matter? So when we're talking about that, we're really looking at proof or presumption. And it was talked about a little bit before, but like pregnancy, we know who the mother is. And with DNA, we know who the father is. You have adoption as another means to legally establish parentage. And then we also discussed like the marriage presumption, where if you're married to somebody, you're presumed to be both the bio and legal parent. Then we also have the issue of biological versus legal fathers. And I think we touched on a little bit, but like the constitutional prerogative of it all, that and the Court of Appeals, Supreme Court, Georgia has beautiful language regarding like the importance of like the parent-child relationship, and that the constitutional right to raise one's child is a fiercely guarded right in our society and law and should only be infringed upon in the most compelling of circumstances. And then historically, when we look at like the laws of legitimation, how we got to the concept of legitimation and illegitimate, it really came from financial support and from the idea of inheritance, particularly like land and title. So I wanted to take a minute just to discuss like the concept of illegitimate, because the concept of legitimacy and illegitimacy comes from this concept of nullius folius, which is nobody's child. So it really was this idea that like the child was of a lower caste, and it's rooted in what's commonly called as bastardy laws that have been around since the 18th and 19th century. And the thing I also wanted to relay was that there has always been a large presumption in law to legitimate a child. So that's where like the marriage presumption comes in. You have Lord Mansfield's rule, which would disallow a married couple from testifying against one another to disprove paternity if paternity was ever contested. So this concept of legitimacy and illegitimacy really comes from the idea of inheritance. So like when in Old England, like if you were an earl, the way that like your estate and your title would be passed along was through the legitimacy of your child. And then later, as we go throughout history, then it also becomes tied to socioeconomics. So that's where we get into like welfare reform. This was already discussed, so I'm not going to belabor it, but there's two issues: paternity and legitimation. Paternity is biological, and then legitimation is the legal recognition of fatherhood. And Georgia is the only state that uses this additional level of legitimation to actually bestow confer the legal privileges of parentage for
Can I
fathers.
stop you for a minute? Would you make that statement one more time?
that Georgia is the only state that has this additional layer of legitimation for legal parentage for fathers. Every other state has a voluntary acknowledgement process. And I'm going to talk about that because that ties into like the welfare reform that essentially equals paternity to parentage. And by parentage, I mean all the rights and responsibilities that flow from legal parenthood. This is just to show like the legitimation process and how they differ. So like with paternity, a number of people can bring a paternity suit. With legitimation, it can only be the biological father. There's evidence of paternity that can be used within legitimation, but these are two very different concepts where paternity is essentially a pathway to legitimation. I also wanted to make the caveat that the way that this presents in the two different courts will look different. So in Superior Court, we think of it more as like the private law. So that's a custody dispute. Like there is no state involvement. It's just mother, father, custody, visitation, things of that nature. So Superior Court's looking to establish this parent-child relationship for those purposes. But when we start looking at the juvenile court, which does more of the public law, that's like dependency and termination of parental rights. The status of being a legal father is what grants somebody standing or being a party to the proceedings. And then that can also dictate whether or not they're entitled to court-appointed counsel, or if they are, if the state is required to perform those reasonable efforts to prevent removal or to reunify if state intervention occurs. So why reform is needed. This gets into like the long-standing legal history, and I will tell you it is complicated and it is a web. So this really started in 93 or 85 to 93 with the federal government having a strong push with Title 4D, which is child support enforcement. And then in 1996, there's the big welfare reform bill, PERORA, the one that changed welfare as we know it. It would happen in 1996. And in 1996, they expanded this idea of voluntary acknowledgements of paternities being used. So in 93, there was this budget bill that said that every hospital had to have them. But in 96, they expanded to say that every hospital and like vital records office needed to have them. And PERORA really encouraged states to use these non-litigation voluntary acknowledgements of paternity to establish paternity, which then led to child support. So in this respect, it was very much tied to child support, but there was also an acknowledgement that parenthood had additional benefits than just financial. So in 1997, Georgia actually amended their law, and that's what I think actually addresses PERORA. So in 1997, Georgia added visitation privileges to the code statute that dictates what flows from paternity. So in that respect, paternity was linked to child support and visitation. Why it wasn't used, I'm still trying to figure that out, but it seems like that was the driver for the reform in 97 was that push by the federal government.
Excuse me, Ms. Buzz. Representative Hefner from Augusta. Quick question for you. So as you espouse about the financial economic aspects of why this was important and it rose to the level of taking action at that time, in the state of Georgia, there are over 56,000 active duty service members serving currently. And Georgia is their home of residency. And that would basically affect over 44,000 children that would be either provided for by those service members. Are you familiar with the state of Texas, who has a partnership that collaborates with active duty JAG for those residents in the state of Georgia, where they have a process where they assist fathers with A, legitimation, and B, this providership of being a caveat or a bridge. Because once this young lady, Miss Connell, she made a comment, and there were a couple of words that were stark for me, and that was cumbersome, complicated, difficult. And when you add the words deployment and combat into the scenario, then that makes it intrinsically different. And if we've ever, as a state or as a body of individuals that you advocate for, considered a model of a program that would at least assist that. Because if we could get at least this piece addressed, it would take it off of the back of our court system and put it into a space where the federal government has provided an advocacy conduit for military individuals, and it would allow us to essentially redirect resources so that we could focus on those individuals who are not benefiting from that. I say that we should probably take a more aggressive position in considering that, because those 44,000 children now have access to TRICARE that is a benefit that would ultimately affect the entirety of their life, as opposed to the possibility of them not having any health insurance, which is a completely different crisis that we are facing as a state. But my question more or less is, has there been any consideration made? Is there a pilot template that you've considered? And would you be interested in participating or offering some research about that type of background and situationally, if there's legislation that we could craft or support or either start to take a more in-depth consideration of?
We would be happy to do any type of research and partnering. And yes, so one of the slides is about the Uniform Parentage Act, which is a uniform law. So there is the Uniform Commission that creates these uniform laws that look to make sure that states are following certain areas of law uniformly. So there isn't a part of the UPA that Georgia has adopted in some respects. So that could be a very good starting ground for where you can get more uniformity.
Mrs. Buzz, we're going to ask a little special, we're going to get out of order a little bit here, if you don't mind. If you don't mind, we'd like to ask you to present the rest of your presentation after our short break that we're going to do at 11 o'clock, so that we can go ahead and hear a little bit from Alexis Putt and also from Kenneth Braswell from Fathers Incorporated. We'd like to y'all just take 5 quick minutes. We got our rhythm is a little out of whack because we're taking a break at 11 o'clock for the prayer vigil at the Capitol, and then we're going to be coming back here. But we wanted to get you in for 5 minutes real quick, and then we'll come back and revisit with everyone after the break.
Chairman Carter, just very quickly, just before we even get to the next 5 minutes, we cannot emphasize enough that Georgia would have to repeal its current legitimation statute to go on to the solutions that we're talking about in the paternity, and we're the only one that hasn't. So we're talking about solutions before, which we should, but we have to get rid of the statute that we currently have before we can do that.
Which requires a two-step process to create a legal father. That's what you would repeal to get to being like other states.
Understood. Thank you for that. And I'd like to welcome Chairman Gunter, Chairman of Judiciary, who is just invaluable to everybody in the entire legislature. And thank you for being here, Chairman Gunter. Alexis Putt, tell us a little bit about you real quick. And I know it's impossible to take on this complicated issue at 5 minutes flat. Good luck.
I have been known to do such things in front of judges who have been very demanding on the timeframes. So my name is Alexis Putt. I'm a senior partner at the Seaman Law Firm. Our primary office is actually located in Mr. Barrett's district. So we're local to Mr. Barrett, Chairman Barrett. I've been practicing law pretty much in that area of family law exclusively since 2009. I actually was licensed at the end of 2008, but started family law pretty early. And during that time, I've practiced in legitimations quite extensively. I actually have had experience with the administrative legitimation process. I know Representative Reese had brought that up in discussions with those problems, and I actually was not part of the problems, but I had experienced some of those issues. In some ways, I guess you could say that it was part of the problem at the time, simply because particular clients had done particular things they shouldn't have, such as agreeing that a father was the biological father when they were not. I actually had to submit a case to the appellate courts regarding administrative legitimation simply because the two parents in that situation had signed it at the hospital when they knew that the biological father was not the person signing the form. It got to the juvenile court, where the juvenile court then declared that father is the legal father and therefore part of the dependency action, which was the underlying case in that instance. And the juvenile court and wanted to keep that father, who was not the biological father, as the legal father and working towards resolving the dependency issues, but the mother was opposed to it because he was not the biological father. So it created a very harsh legal situation in which that statute had no ready options to actually overturn that administrative legitimation. And just as sort of a suggestion, as potential remedy to the constitutional questions raised by Ms. Connell, is that assuming the parties want to go through a legitimation process, I do not see any reason why the court or the hospital at that point could say, well, if you want the administrative legitimation process, submit whatever constitutional rights you have in order to submit to the DNA test, and then we can administratively legitimate you at that point. If they refuse to do that, that's fine. They just can't do the administrative legitimation. So I think in that instance, revising, I believe it's 19.7.21.1 to include protections for biological assertions will help resolve some of those issues. But just to kind of give you a little bit of an idea of where the expense and problems are in actually pursuing legitimation cases, because I get so many calls from fathers who say, I just want to see my kid. They're not concerned about the child support. They're not concerned about those types of things. They just want to see their kid. And right now, pursuant to the 19.7.25 statute, all custodial rights are vested in the mother until the father legitimates. Now, the statute itself on legitimation does not provide for essentially what would be temporary relief in the middle of a court case, saying that this father can have visitation rights until final determination of the legitimation is going on. However, attorneys at my firm actually argued an appellate case, and there is, as far as I can tell, a single appellate case that my firm was part of that essentially said temporary hearings and granting custody to fathers while the legitimation action is ongoing is allowable. Because it's not written into the statute explicitly, that causes a problem for the judiciary. And so when they go through these cases and when the fathers are paying for the attorney's fees and hearings, just trying to see their kid, that is where an extensive portion of the costs come in. And just the legitimation in and of itself, the burden upon the father to get legitimation, I think, is a little bit one-sided. So in order to legitimate, a father must show that they have not abandoned their opportunity interest. And then if it's in the best interest, then it's legitimation. I think that's a little one-sided on the burden between father and mother as to prove legitimation.
Perfect. Will you be available to join us after this short break we're taking?
Yeah.
Love to have you back here.
Absolutely.
Can I ask you a quick question?
Yes.
Real quick. So what I think I heard you say, in Kelly and Regina, just a yes or no, if you like the summation there. Make it optional. There's a biological component. If the father is indeed the biological child, administrative legitimacy should be possible, and we can have that filed through the vital records process or whatever. Is that what I heard you say?
I believe that would be the case. And then as to the document issue they brought up about finding the documents,
Right.
The problem with those was that they were considered confidential documents, much like a DFACS record,
Right.
and therefore you required a court order to even go after and find them. That was the significant issue with getting those documents. So if this committee, and of course through legislation, could make it more readily accessible, such as birth certificates are, getting that form, having that biological component would substantially assist with the administrative process.
Regina,
Thank you.
you two agree with that?
A qualified maybe on that,
Okay.
that there's a way to do it.
Okay.
Okay. Is Mr. Braswell in the room? Mr. Braswell, the Speaker of the House has certainly recognized the importance of this issue. And he's also having this prayer vigil at the Capitol. And I think it'd be a great idea if we went over there and supported that prayer vigil as well. And it'll also demonstrate this is a great turnout. And
Man of God, I'm not gonna interrupt prayer.
very good, sir. But are you okay with returning afterwards? And
We do want to hear from you, Mr. Brazil. We thank you for taking time.
if y'all would indulge, we really appreciate your flexibility on that. And let's take a recess now. We'll reconvene at the end of that. It should be over by 11:30. So thank y'all.
So.
Wow. Thank you so much, everyone, thank you for your indulgence on that. I think that was probably time well spent. I feel better. And yeah, if it's okay, we're going to sort of pick up with Alexis Putt. If would you mind? We'd like to get you to sort of continue where you were and sort of summarize again. You're talking to me, so dial it down to a digestible presentation for a guy like me.
And when we're looking at the legitimation process through a litigation perspective, we have three components that really sort of most of the time get addressed all at once. You've got the legitimation itself, child support, and custody. The child support and custody components are going to be the same whether it's divorce modification cases. So those sorts of things obviously can raise the costs of just a simple legitimation process simply because they're add-ons that are part of that. So we can't really look at shortening those processes because those are sort of well developed in both the statutory and case law scheme. So the complex issue, sometimes where we see some unnecessary expensive in the legitimation itself, exclusive of child support and custody provisions, are simply things like temporary custody. Currently, like as I was mentioning before we went to break, there is a single case law, so far as I know, that says that this is okay. And when you're looking at it from a perspective of a court system, hunting down a single case in the entire case law history is a little bit difficult. So oftentimes what courts will do is simply defer to the statutory scheme, which says the father doesn't have any visitation rights. So when the father is simply trying to just see his child, the costs that are associated with that become substantial, even when we're just looking at the legitimation itself. There's also oftentimes, as part of that, a fight over the legitimation as a basic fact. And the way the scheme is set up right now is you first have to show that the father has not abandoned his opportunity interest. That's a complex way of saying, has he been in this child's life? Has he supported this child? And they look at that over the course of the child's life. Obviously, it's harder to abandon your interest in your child if the child is 1 month old versus trying to legitimate when the child is 14 years old. So those factors can become much more complex the older the child gets, and it can be much harder to show whether or not the father has abandoned the opportunity interest. So once the father has essentially got past that portion, he then has to show that it's in the child's best interest that he be legitimated. So in one way, we have a custody statute that says there shall be no presumption in terms of custody between the mother and father. The way our laws are set up for the father, there is a presumption that is unbalanced. So the mother never has to prove one fact, that it is in the child's best interest that she just be in the child's life. We're not talking about custody. This is just a matter of, does this father get to be a factor in this child's life when we're talking about legitimation? But we put all of this burden on the father to actually show those things, show that he hasn't abandoned his opportunity interest, show that it's in the best interest of the child. So when we get from a practice perspective, when I get a mother, for instance, and I sit her down, talk to her, tell her the laws and these sorts of things, a mother may be under the perception that it's not in the child's best interest because it seems like sort of a low bar for the mother to say it's not in the child's best interest that the child be legitimated. So that oftentimes leads to excessive litigation over this simple issue. And so if it's sort of like incremental changes, if we could shift that burden perhaps to make it a little bit more presumptive in favor of the father being legitimated, which is as it should be, even in a judicial context, I think it would make a substantial change in the litigation side of things. Because if I can go to a mother and say, look, these are the laws, you don't meet that burden, this should be an issue which you agree to, then that actually short circuits the legitimation process by quite a bit, just by improving that. Something as simple as saying that it needs to be clear and convincing evidence that the father not be legitimated. Place the burden on the mother to prove more of a higher burden, which is clear and convincing evidence is short of what we would look at in a criminal context, but much more in a best interest standard. And so if I can tell a mother, we even use it in dependency statutes for clear and convincing evidence to remove a child from the parents by defects. If we're not placing that burden or saying that that's the standard in which a father's rights are removed from him in the legitimation context, it seems to be a disconnect. So we're saying it's harder to remove the child in this one context via the clear and convincing standard, but in the legitimation context, it's not as hard. His rights can be ripped away fairly easily with just using the best interest standard. So if we place more burden on the mother by adjusting just that little bit of the statute, I think that will have a dramatic effect on, at least from a practitioner perspective, of what we can advise mothers and fathers as this is going to happen in this particular instance without making it just a certainty. So even a clear and convincing standard would allow for egregious instances such as abuse and those sorts of things to say it's not in the child's, it's not clear and convincing evidence that that legitimation should be denied in these particular contexts. So yes, Representative.
Quick question. As you're talking about that in the court process of it, and I guess it's for you too as well, anybody who can provide clarity, it is my understanding, as we've been researching this topic, that some people in the adoption world had some challenges with I don't know if it was the administrative legitimacy process, or there were certainly some concerns from that entity. Can any of you articulate what was their concerns and how do we avoid that this time?
I can't speak exactly to that issue because there's a substantial change in the adoption code in 2018, and that sort of revised everything and how it relates to legitimation processes. And of course, by that time, we'd already repealed the administrative legitimation. So under the current adoption code and administrative legitimation, they never really met each other. And so it really wasn't an opportunity to see a problem with the current statutes and the administrative legitimation process. But I would, depending on how dramatic a change you make to the legitimation statutes, you probably would want to consider that as a possibility. If I had to imagine what could have been the issue, in part, the records were, as I mentioned, they were incredibly difficult to get. They required a court order and months to actually do that. And they were, as I said, they were akin to getting DFACS records, which required essentially motions to be filed, a judge to consider a motion for an in-camera review. The DFACS records had to be produced to the judge. The judge would then review them and produce them as necessary. And the same sort of process was required in trying to get the legitimation form. In the case I had mentioned earlier, some years ago, we did have that problem of trying to get the form. Now, in a juvenile court context, it was actually relatively easy just because some of the issues, and in a dependency context, it was a little bit easier to address these issues with a juvenile court judge to actually issue an order. DFACS was regular in juvenile court and could produce certain records and things like that. And so as far as those things go, getting that form was relatively easy. And then, as I recall, the interesting thing about that form was it was just an appendix basically at the bottom of the paternity form. So it was almost like a secondary paragraph on the form itself. So just the paternity form itself and legitimation form, since they were pretty much one form, was difficult to get once it was actually submitted to the hospital.
I've heard a wide range of opinions on legitimation from the one person, maybe a judge or a lawyer, that says, "Oh, it's fine. It really works, and we don't really need to change anything." I've heard people say we need a top to bottom kind of look-see and an overhaul potentially. And I've heard here's some incremental changes that can be made to enhance the legislation. And today, this is a first pass at this. We've got, we're working in anticipation of being back in session in January. So, we don't expect Rome wasn't built in a day. So at a very high level, as before we leave today, I'd love to hear from each of you. Is this hey, that it works okay, it's a little clunky, or it's appalling and it's bad and we need a bottom overhaul, or are there incremental changes, and kind of which camp you fall into? If that's a fair question. I don't know if it is.
Well, I understand Ms. Connell's perspective that it needs to be an overhaul, and not that I would be opposed to an overhaul, but I think that incremental changes can make dramatic impacts in these sorts of things. There are certain statutes that could be tweaked a little bit necessarily to provide some relief, particularly with indigent or low-income fathers, such as I mentioned earlier, about changing that presumption might make the litigation process a little bit harder, or excuse me, easier to predict, at least in favor of advising clients on how to move that particular issue forward. I think another issue is, and this may help also if certain things are more available to juvenile courts, for instance, guardians ad litem. So that is also a significant issue that causes expenses to rise in the superior court context. So oftentimes guardians are just de facto appointed by judges in the custody context. So a judge may have a different perspective because they don't see the investigatory side of it. They'll just have a guardian ad litem's report. That report just comes into it. They don't see everything that went into that. So they can have a little bit of a distorted view as to what finally comes in front of them, as opposed to what's actually happening on the side of the practitioners. So guardians can often weigh in not only the custody issues, but the legitimation itself, because it's a best interest issue. So if a guardian is trying to recommend what's in the best interest of the child, the guardian at the very front end of the case is investigating and determining whether or not it is in the best interest of the child. Now, some of that, like I said, as I mentioned earlier, an incremental change in changing the standard, the burden upon saying that the father is not the father, basically making it harder to say he's not the father or should be legitimated, could alleviate some of that. But when you're looking overall at the cost of the guardian ad litem, another potential outlet, or sort of a pressure valve, at least as far as our superior court systems are concerned, because a lot of the systems, particularly Fulton County, are overwhelmed with the number of domestic cases. Fulton County even has a separate family law division. That's all they hear, and they are still overwhelmed. If we could shift the burden a little bit more to the juvenile court side, where original actions could be filed in juvenile court. So right now, there's concurrent jurisdiction for legitimation, but only in certain instances. One is which there's a dependency action, so you can file legitimation there. Another is if the superior court sends it there simply because they want custody to be determined in a legitimation action, or the legitimation action itself can be just completely transferred to the juvenile court system by superior court order. Now, the problems with that, although it is available, simply having to file a motion, having responsive briefs from attorneys, having hearing an argument from the judge can be problematic, particularly in a county like Fulton County, where it's difficult just to get a hearing on any issue. That can take months. And anytime you're extending the case by that far, you're talking about the cost. So if we could change the concurrent jurisdiction to allow original actions for legitimation to be filed in juvenile court, and then potentially using those resources, such as readily availability of less expensive guardians, because most of the juvenile court systems have guardians that are essentially accept lower rates. They also are set up to address indigent litigants, and so provide those services. I know some counties in particular already sort of do that. So for instance, Gwinnett County, if I were to submit a petition to them for legitimation, and I argue to the judge, no, we can't have a guardian ad litem because our client can't afford it, that judge would right then and there almost consider transferring it to juvenile court automatically just to get apologize for that, just to get a guardian ad litem appointed to the case. So if we could start the action out there, thereby sort of bypassing the need to file a motion, I think juvenile court could be a substantial resource both in getting a case actually finished, because the juvenile courts judges are usually more available than superior court judges.
And this, what you're talking about right now, is really getting to the heart of the affordability side of it, because the more hearings you have to go through and the more appearances you make before judges, the more expensive it is going to be for the fathers that are pursuing this. And as you stated, the burden right now is totally on the fathers. And I do want to clarify, just for the people in the room, when Ms. Let me sure I got your name right, Ms. Putt, right? When Ms. Putt used the phrase "best interest of the child," it's not just words she's using. That's the actual legal standard that is used in family law to determine how a judge should be deciding a case as it relates to a minor, the best interest of the child. And so Well, that's a great perspective, and actually, what you have, what you're proposing, Ms. Put, I can see this working in conjunction with what we heard earlier from Miss Katie and Miss Regina, because in my eyes, we're looking at different phases. What we talked about earlier is the possibility from the beginning, and now we're talking about someone who may not have, let's say hypothetically, it's changed to this. We're talking about someone who may not have pursued that option, and now they're having to go through the court system. And so we do need to look at the multiple levels of levels. I just want to make sure from a conversation perspective, we're in the right context. Ms. Regina, I do have one question for you, real quick. It is something you mentioned earlier. I just wanted it's a lot of scope, Mr. Chairman, but I have to ask, how productive is it to suspend someone's license for child supports in arrears? It does that not have an adverse effect on them being able to get to work or actually working to pay what we say they owe?
Well, I might have to get back with you, Mr. Vice Chairman, on the efficacy of it in terms of whether there are any stats that the division keeps about whether or not it affects our collections of arrearages to do it or anything like that. But I just anecdotally, this is my personal experience from practicing before this role. It has an adverse effect on someone who's trying and appropriate motivation for someone who can pay but isn't. So that's like many things, it depends on where you sit. So when you say somebody asked, is it working? Mr. Chairman asked, does the legitimation construct work? It depends on where you sit. So that's the problem with doing what you all are undertaking. If it were easy, it would have been resolved a while back. It would have been resolved when we went from legitimation, as Katie mentioned, we went from a 3-step process, meaning that you had to prove paternity, and then you had to file another action to legitimate. Then you had to get the legitimation order. Only then could you have to file a separate action to get your visitation and your custody. It was a 3-step process. Now we're down to 2. You establish the paternity. Still got to get your legitimation decree to get custody, on equal footing, with the custodial parent, with the biological mother. So, from many moms' perspective, I can tell you from representing them over the years, it works just fine. Because they may not have a relationship with the biological father, and they may be telling a judge and telling their lawyer, this is really about harassment. This is really about intimidation. They're not interested in the child. So the harder you make it, the better off it is. But from the standpoint of folks who are already in their child's life, and we see this in the division some, where we are establishing a child support order with someone who is already in the child's life, the father, the biological father of the child, and you then have to tell them that they have no rights. They're a legal stranger to this child, even after you've established paternity with a paternity decree. So it does not work for those folks, and it disproportionately affects lower socioeconomic citizens who cannot afford a private attorney. And that's just, in terms of, again, does it work? It depends on where you sit. I don't know if that answers your question or not.
I understood that perfectly. Representative Hefner?
Yes, sir. Thank you, Mr. Chairman. So is it fair to say that the process as it is biased in favor of women and does not require them to have any share in the cost or the loss in terms of the journey as it imposes that substantial financial element on the non-custodial parent or the father?
I wouldn't say that the system is biased. What I would say is there are some presumptions and some processes built in that favor stability, meaning maternity is always known. Paternity has to be established. And in the context of an out of wedlock child, there is a presumption in the process of stability. And you don't get to interjection of someone else into the mix until you're very sure that that person has a commitment to the process. And is it an overcommitment? Is it too much? That's for the policymakers to decide.
So when you say based upon the maternal situation, then that's stability. But based upon the best interest of the child in that illegitimate state, is that stability?
I think, again, that's what's complicated about family law. There's all sorts of gray in what family lawyers do, and everybody's situation is different, even though it may look the same from the outside. And that's what's difficult about developing a system. So
Is
just,
that fair to the child to presume that stability is with the mother automatically, even in this situation? Is that is what I'm hearing you say is that is the part that makes it unbiased
it's a difficult,
or biased.
it certainly is difficult questions to answer, because then you have to, if you're talking about just biology, whenever we talk about that, and I have this conversation with folks, then we have to talk about, what about a child of rape? If
Sure.
you're creating a situation where biology equates to legitimacy in an out of wedlock, then what do you do there? So this is more complicated than it looks at first blush, which is why I'm glad y'all had a prayer session and we had a prayer session we could go to as we try to grapple with this. It's difficult.
And I'll add, Representative Hefner, to your question. In terms of the expenses related to the pursuit of this, I mean, it is a two-step process right now. It is my opinion that should be streamlined in some form or fashion. And it is my understanding that other states, nearly all or all of them, have figured out a way to streamline it in a way that Georgia has not. But I will say, in my experience as a family law practitioner, if a mother wants to make the legitimation process difficult, she can, but she too will have a significant expense associated with that. I don't think it's fair. I mean, when you're engaging in litigation, there's expense on both sides. Now, is it fair for her to put that expense on him? Well, the reality is you can't make a blanket statement, yes or no, because we have plenty of Georgia case law and gazillions of examples where the court ultimately found that the father, didn't have any business being a part of the child's life, that it was not in the child's best interest. So there are, and then there are, of course, plenty where the courts find easy, yes, dad should be in the child's life and mother is causing problems she shouldn't be. But there is no cookie cutter answer to that question. And if I may, Chairman.
Go ahead, and we'll sort of wrap that up. Then we're going to sort of suspend for a minute. I'd like to, Representative Smith has a question as well. I'd like to get in, and then we'd like to shift over and hear from Mr. Braswell for a few minutes, and then we'll come back and we'll circle back around. We want to hear the rest of your presentation from the Barton Center, of course. And so, yes, go right ahead.
So with all due respect to my fellow family law practitioner, Ms. Putt, I'm going to respectfully but adamantly disagree with the suggestions that she made about shifting the things to the juvenile court. And I would remind the committee or inform the committee that it used to be that only the juvenile court had the jurisdiction, that there was not concurrent jurisdiction. And it was a 2015 amendment to OCGA 1511-560 and OCGA 1128. I mean, these are the statutes that were affected by this that gave concurrent jurisdiction. It used to be limited to the juvenile courts, and that caused significant problems in our court system. And so the legislature amended the statutes in 2015 to give concurrent jurisdiction to superior courts and juvenile courts. So I would say we already tried it with just the juvenile courts. And so don't go back to what we've already learned here in Georgia was a problem. I would also submit to you that while I certainly agree with Ms. Putt that there are counties, and Gwinnett is a perfect example, and in my experience, it is true that they will sometimes transfer cases from the Superior Court to the juvenile court in Gwinnett County to deal with the custody issues. They do have staff guardians ad litem in the juvenile courts in Gwinnett County. However, number one, as with all systems, that is an overtaxed, overburdened system. So I would caution you to further tax that system. Also, those guardians who are staff guardians for the juvenile court are trained. These are lawyers who get a lot of continuing education and a lot of training to be staff guardians for the juvenile court, where the focus is almost always deprivation. And so when you are transferring superior court cases to juvenile court, where the standard pursuant to 1993, and Representative Reese mentioned it a minute ago, that's the best interest standard. That's our code section that gives us 17-point factor list of what the court needs to consider when looking into the best interests of a child when considering custody. That is an entirely different standard than the deprivation standard, which is what the juvenile court staff guardians are trained on and focused on, because that's what a majority of their cases are dealing with, is deprivation. They do not have the same level of training. I'm not saying they don't know it, but their primary focus is on deprivation cases. That's where their training is. That's where their work is. So when the Superior Court is shifting cases over to them, we are often putting them at a disadvantage, not just because we're overburdening those resources that were not intended to be used that way, but also because we're looking for professionals who have a wonderful skill set, but it is not in best interest standard cases. It's in deprivation. And we're asking them to put on a different hat without supplying them with the right resources and training to do that. For purpose of reference for the committee, and I did not bring a copy of this to you, but I will cite it for you. There's a case, Mathena versus Brumblow. It's a Georgia Supreme Court case, May 18th, 2020. The site is 308 Georgia 714, and it's again a 2020 case. That's the case that addresses that issue with the concurrent versus individual jurisdiction in the juvenile court versus the superior court. So that has been well fleshed out. I would also commend or recommend to the committee that you consider the case of Brine versus Ship, BRINE. Ship is SHIPP. That's a 2012 case of the Georgia Supreme Court. And I know Ms. Quick is well versed in this. Also, it is a jurisdictional case. That's an important case for y'all to look at, again, just to understand the complexities of this and the gray that, what seems like an easy solution, cookie cutter thing. I mean, this case involved a 13-year-old child where.
Okay. Well, and I'm operating under the assumption that this is going to be a process. Obviously, it's very involved, very complicated, and we look forward to all the feedback, input you can give us. Any examples like that, we're all ears, and we hope that we can have a continuing dialogue and getting input from you. I think I understood the spirit with which Ms. Foote meant. I think she was saying there are other places that seem to be able to move things more quickly and more efficiently, and looking for those. So I value that thought process, and I certainly understand your point as well. I have someone that I just respect immensely who happens to be sitting over there on my right-hand side, who's a former Superior Court judge and one of the finest legislators I ever met, in Stan Gunter over there. So I'm glad that he's in this room with us today. Representative Smith.
Thank you, Mr. Chairman. I think I've heard a couple of times mention about Georgia does it different than other states. Could you think about it a while at the next meeting, could you offer up your top priorities? Is it top 2 or 3 other states that really do a good job? Recommend those to us. Therefore, we could look at the laws of each and maybe take all 3 or however many you want to give us and put them together to come up with some recommendations for us.
Sure.
Yeah. Okay. Thanks.
Thank you. Okay. At this time, if it's okay with y'all, the rest of the committee, I'd like to ask Mr. Braswell to come up and introduce yourself, please. Tell us exactly who you are and and do us with great knowledge.
Wow. This is a emotionally charged day. I've been waiting for 10 years for this moment. These 3 little pages represents 10 years of concentrated, condensed thought. And what I'd like to do is get through these pages for you, Chairman Barrett, Vice Chair Reese, and distinguished members of the committee, so that I can make sure that at least my calculated words are on paper and on record. And then I want to take a few minutes just to step back and kind of address some of the things that I heard and give you the perspective from which I'm going to be speaking to, different from the perspective that I've already heard. And so the 2 perspectives that I'm going to bring to you today is from a service provider's perspective and from the perspective of a dad, because we have not yet to hear the words of a dad today. And the service providers, who my staff is represented here, are primarily made up of moms and dads who has families, some married, some not. Some are co-parenting with fathers who are involved, some are not. Some of them have child support orders, some don't. Some have gone through legitimation, some haven't. So every scenario that you can think of with respect to legitimation, I have seen over the last 10 years. And I want to make sure that I address all of their things. And so I want to thank you for the opportunity to speak today, because I think your thoughtful leadership in establishing this study committee through House Resolution 428, your focus on improving the affordability and accessibility of Georgia's legitimation process is timely and essential. As many of you are aware, in Georgia, the process by which an unmarried father becomes the legal father of his child is not automatic. Even if his name is on the birth certificate, he must file a petition for legitimation and be granted legal rights through a court process. This step, while critical, is often misunderstood, misapplied, or simply inaccessible to fathers who need it most. House Resolution 428 rightly states biological fathers who wish to obtain parental rights are often discouraged by doing so due to a lack of resources or awareness of the costs associated with legitimation. And from our experience working with thousands of fathers across the state, I can assure you that this is not just a policy issue. It's not just a legal issue. It is a human issue. If I could step away from the paper from a second to explain to you why this is a human issue, because the work around anything related to children, and in this case, parenting time, custody, legitimation, child support, is one of the most emotionally charged, sometimes toxic issue that you can deal with. So in many of our cases where we think law and policy can regulate how humans interact with each other when they're at their most vulnerable times, just doesn't work. And I can show you case upon case upon case with very logical, God-fearing, stable, professional, not so professional, formerly incarcerated, whatever. When it comes to their children, logic is not part of the thing that centers them. What centers them is this thirst to be right with respect to trying to have access to their children. And when there is something in the way of that that they can't explain out, it's very difficult to get them to understand that the process is something that we need to work on, because the urgency of getting to their children can't wait for the process. Here's the problem. Georgia does not have a standardized statewide process for legitimation. Instead, depending on the county they live, fathers encounter varying expectations, paperwork, court procedures, and legal interpretations. This inconsistency creates confusion and delay. In some cases, it even causes the fathers to give up on their rights altogether. We cannot overlook the fact that this gap disproportionately impacts both urban and rural low-income families, many of whom face additional structural and economic barriers. What should be clear, or what should be a clear path to legal fatherhood, becomes a maze, one that too often results in children growing up without the full presence and protection of both parents. From the 2021 Kids Count data profile, we know that 18,000 894,000 children in Georgia live in single-parent homes. We also know that 650,000 children have parents who lack secure employment. 711,000 children live in households with a high housing cost burden. These numbers are indicators of instability that could be mitigated in part by strengthening the presence and legal rights of fathers. At Fathers Incorporated, we're at the front lines of this issue. Through our Gentle Warriors Academy, funded by the federal fire grant, we serve hundreds of fathers across Georgia, providing case management, workforce readiness, parenting education, and legal navigation support. Since 2021, over 900 fathers have graduated from our Gentle Warriors Academy program. Of those, 91% report increased confidence in parenting ability. 87% gained employment and improved their economic situation. 68% improved their co-parenting relationships, and 41% initiate or complete the legitimation process with our direct assistance. We are proud to report that more than 230 fathers successfully completed the writing of their petition with the support of our team, many of whom had previously been disengaged or unaware of their rights. However, only 80% of those who complete their petition actually file their petition. And the question is why, if they go through the entire process of getting the petition filled out, why don't they then put it into court? And it's not because of the lack of love or commitment, but because they fear the process will strain their co-parenting relationship. They also feel like they can't afford the legal fees and they simply don't understand what's required. Took a step back from the paper just to give you a scenario. Imagine a couple that has a baby. He is trying to legitimize the child. They haven't been together for a while. They're not on good terms. They're struggling with trying to communicate, but both of them love their child equally. He's just trying to have access. He wants parenting time. He wants to do what everybody expects him to do, but there's a legal process that's causing a barrier for him to be able to do that. He comes into the space of Fathers Incorporated and we say, we have a program that we can run you through, but you have to take one half of our curriculum before we bring you through the legitimation process, because as an agency, we want to know who we're working with. We're not in the business of just doing legitimation for fathers that we don't know what their character base is. We don't know what their agenda is. So they have to spend 4 to 5 weeks with us in curriculum before we even allow them to begin the legitimation process. He goes through that. He graduates from our program. He walks across the stage with his cap and gown. He has his legitimation pages in front of him, ready to go to the court. And he doesn't do it because he knows that in order for the legitimation process to take place, the minute that he files it, she has to be informed. And you know how she gets informed? By the sheriff. But let's sit with you for a minute. And he's thinking, oh, wait, I don't know if you ever had the sheriff show up at your door, but that ain't a good thing. But that's the process that happens. Now, the little relationship that he had is now destroyed. And now his, what could have been an uncontested legitimation filing is now a contested one, not because they don't both have the best interests of the child in their minds, but now they're just simply mad at each other. And they're fighting at each other because how dare you have the sheriff show up at my door. Now all of the other things come into place. The legal fees, trying to find a lawyer. Now he can't see his child. The relationship is deteriorating. And I just wanted to stop there because they're part of this process that I want to make sure that as we walk through understanding what the laws and policies are doing, at the same time, what's happening to people, what's happening to couples, what's happening to children. Our work with legitimation doesn't stop there. Fathers Incorporated is currently a key implementation site implementation site for a national randomized controlled trial led by MDRC. This research evaluates explicitly how fatherhood program services, including legal navigation, parenting support, and co-parenting education, impacts a child's ability to legitimize his child. As one of the only states that separates paternity and legitimation, Georgia is uniquely positioned to benefit from these findings. Fathers Incorporated also leads applied research through our Moynihan Institute for Fatherhood Research and Policy, which recently released a data brief linking legitimation status with youth academic outcomes. It shows that having a legally engaged father is associated with a child's better school performance and reduced behavioral incidents. But while we talk about the gloom and doom, today is the start of an opportunity. I really believe that. And I want to share with you a couple of recommendations. One, it has already been said to standardize the legitimation process across the state, develop uniform guidelines and documents, also use accessible language and make resources available across platforms, also eliminate filing fees for indigent fathers, and streamline uncontested cases, meaning that in the log, when there is an uncontested case, have a scenario to which those can be fast-tracked through so that the child can be legitimated, and you deal with the contested ones in court like you would deal with any other dispute. Number two, expand funding for legal support and navigation services. Fund community navigators for legal aid for fathers. Replicate models like GWA programs across the county. We wish we could do this work statewide, but the on-the-ground work needs resources. We have the capacity, we have the understanding, we have the know-how, but capacity to be able to serve all of the counties of Georgia is something that we desperately want to be involved in and want to do. Three, integrate legitimation into existing family services. Provide legitimation information at hospitals, DFACS offices, and through child support services, and align that with paternity acknowledgement procedures. Use data to drive solutions. Establish a centralized system for tracking legitimation cases. Identify regional and demographic disparities. And lastly, build a statewide awareness campaign. Normalize legitimation as part of responsible parenting by supporting public education through campaigns, blogs, podcasts, and trainings. And so that's the on the record stuff. And then I want to just kind of touch just briefly some of the things that I've heard. Representative from Augusta, you talked about military dads. We are currently in our 5-year contract. We just expanded the scope of our contract in the last year to expand outside of Metro Atlanta. And in a couple of weeks, we will begin our first cohort in Columbus, Georgia. We're now ramping up the cohort in Columbus to begin to start seeing what our program looks like across the state. In addition to talking to folks in Columbus, we're also in conversation with Fort Bennett. Because one of the things that I also want to do and had a thirst to do is see what this work looked like on military bases. And so we would love to come to Augusta and have conversations about how to ramp up a fatherhood program in Augusta. I also want to be clear that although we provide services in Metro Atlanta and it is primarily rural, that I also understand urban dads. In addition to my work at Fathers Incorporated, I am also the director of the National Responsible Fatherhood Clearinghouse under the U.S. Department of Health and Human Services, and we've had that contract for 15 years. We have served that contract over 4 administrations, and we've done, including the current, and we continue to do well in every area, every scenario of the country, whether it is in the South, in the North, in the Appalachian County, in the Northwest, in the Northeast, wherever we have gone, we have been successful in doing our work over the last 15 to 16 years. Why doesn't it work? Or why didn't the acknowledgement for paternity work? It is because there is no entity that's in charge of holding accountable the process. So part of what has to happen with the legitimation is that it has to come under an authority, whether that is a state agency, whether that is a committee, whether it is you all, someone has to have authority over the process. And so with all of the great suggestions that we made, they're still being made piecemeal. And until that entire process comes under one authority, and that authority are held responsible for being able to tell us, here's a stat that we don't know. Think about this. How many children currently live in the state of Georgia that are not legitimated? We don't know. The only thing we do know is how many children are born into out of wedlock households. I can tell you that in the state of Georgia, close to 60,000 children every year are born in the state of Georgia to out of wedlock households. Over the years between 2000 and 2010, that number amassed to about 600,000 children in the state of Georgia that was born. But I could not tell you of those 600,000 children, how many of them are currently legitimized. That's a problem. We got to be able to track that data. And then the last two things, I'm glad you brought up adoption. I have an answer to that question because we've done some work and we've come up against the industry in understanding what it is. And it is in part, not in whole, that if fathers had automatic legitimation, it would be an entity to which adoption firms and child welfare would then have to engage the paternal side of the family. If the father is not legitimized or the child is not legitimized, the adoption agency does not ever have to look for daddy, grandmama, grandpapa, auntie, or uncle. He is literally X, that the paternal side of the family is X out of the equation. And it makes it easier for adoption agencies to move children into child welfare agencies if they don't have to deal with contested cases from legitimated fathers. And so there's a conversation that has to be had with those agencies to show that there is a benefit when it happens, that while it may slow down the process, it doesn't destroy the process. I think that there has never been a conversation between responsible fatherhood and adoption. And it's a conversation that we are well open and well ready to have, to kind of talk about what that looks like so that we can put something in place that would help in that space. And then lastly, you talked about license in jail. Yeah, it's a bad thing to have your license taken, and it does impact you significantly, particularly in an economy now where your car is your vehicle to employment. And if you are on child support and have responsibility for children and you do not have a license, how can you possibly provide for your child? But there's one that's even worse. And that is when they're put in jail because they can't pay child support. And many of those fathers have also not legitimized their children. So they've gone through the paternity process to establish paternity so that child support can be taken from them. But they haven't been able to legitimize. And now, because they're not paying child support, they also have to go to jail if they're not paying child support, which leads me, and I said that was it, but I did have one other thing because we were talking about the different buckets. So there's 3 different courts. There is the child support court. There is the court that deals with parenting time and custody. And then there's this thing called abandonment court. Abandonment is when a father who owes child support hasn't paid his debt for more than, I believe, 60 days, 30 days. If he doesn't pay his child support in 30 days, the custodial mom can go in and apply and bring him to abandonment court. Abandonment court is civil. What happens at that point is he has to negotiate with the judge what he is willing to do and what he can do. The process is if he doesn't comply, every 30 days with whatever the judge gives them, he can be locked up on site. One of my staff people is in abandoned court every Wednesday in Clayton County, because Judge Keisha Hill Wright, which is phenomenal. And everybody says there's some biasness. It's bias is in the eye of the beholder, just like offense, right? And so when we talk about bias, we always got to talk about it from the perspective of the person who says this system is even biased, or I have been offended. You don't get to judge that. If I say I'm offended, I'm offended. If I say it's biased from my perspective. But in that court, we have to kind of begin to start figuring out who is the authoritative entity in the state of Georgia that brings all three of these courts together so that services can be provided for this dad, so he doesn't end up in a situation where he simply gets locked up because his license was suspended and he couldn't make it to the court date because he happens to live in a county that's 5 counties over. And you want him to Uber there. And so that's the human side. The daddy side of me is the crushing of my heart when I hear dads who come up to me and say, just had one the other day. I ran into him, can't even remember where I was, but I had on a shirt and it said Fathers Incorporated. And he said, Mr. Braswell? And I said, yeah. He said, I saw your shirt. He says, I just wanted to thank you. And I said, for what? He said, because of your organization, I got my child back. Right? That's priceless. And it happens for me more and more and more of the dads who successfully go through legitimation. Not only are they thankful, but the other piece of this and the other voice that has to come in this is moms who also understand the difficulty in this process. And they want these fathers to be legitimized, but they see the struggle and difficulty in these fathers coming through as well. So we have to bring in these conversations with mom, because just as dads are uninformed, unaware, and doesn't really understand the process, neither do moms. They learn it the same way we learn it, baptism by fire. That's it. That's all I have for today.
Thank you. Thanks, Mr. Braswell, for that presentation. And like the father you encountered, I want to thank you for your over a decade of work helping fathers unite with their children and going through the legitimacy process. And what I appreciate the most about what you do is you also incorporate accountability.
Yeah.
And make sure that that person is ready for that type of work. We would love to have your recommendations if you could have those officially submitted to the committee.
They're in that package.
They're in the packet. Okay. All right. Well, we will certainly make sure that we take those into consideration. It was great hearing the aspect of a father. So thank you again, sir.
Thank you.
Yeah, thank you, sir.
Safe travels.
And our lawyer analyst friend here, Rock Perry, will speak with all of you and get you information so that other information that you feel is useful to get to us, please do so. At this time, we'd like to go back to Mrs. Buzz and let you please come finish your presentation from the Barton Child Law and Policy Center from Emory.
Well, no, click me. I like it.
In a minute.
Oh, it took a break. Its computer was praying too.
Yeah.
Ms. Booth, as we continue with your presentation. I'm very interested in, I think we were at the point of talking about the direction for reform.
Yes.
You were at that part of the presentation. I know you were talking a little bit about the UPA and the Uniform Parentage Act of 1973. So I assume you're going to expound upon that a little bit. And we also extend the same courtesy to you if you have anything in particular, any policy you want us to consider. If you see some best practices in other states around the nation, please submit that to us so that we can have that as a part of our final report
We happy to.
and recommendations.
We happy to.
Yes.
Well, while it's warming up, oh, that one. Well, that one. Look over there, everyone. So I was at the point where we were talking about like how we got here. And so a couple things came up that I wanted to address, and I love the dialogue and the really thoughtful questions. So some of the questions were like, what went wrong? And so I talked about in 1997, Georgia amended its laws to include visitation privileges with paternity. And then in 2005, that's when they introduced legitimation through, in the way that they did it was like, you could have a statement on a voluntary acknowledgement of paternity that says that you consent to legitimation. There was no real guidance. It was just a statement that was put on an acknowledgement of paternity. From that statute, there are 4 Court of Appeals cases that came about. And from what I can tell in looking at the legitimation subcommittee that was formed after these decisions were made, were kind of a driving force. And some of the issues that they raised were the fact that you couldn't get the acknowledgement after it was given to Office of Vital Records. So it goes to the issue of like, it was this protected document. So 2 of the cases, or 3 of the cases, were about a duplication, essentially. There was an administrative legitimation, and then they filed a petition, and then the petition was denied, citing lack of best interest, but then the father moved to set aside that decision because he was already legitimated. So that was some of the issues that the court was seeing, was the fact that it was creating this process of duplication. And then another issue that came up was the idea of fraud, because one of the cases, and it might have been the case that kind of pushed things over, was an inheritance case where it was a non-biological father who knowingly signed an acknowledgement of paternity to a child that he knew wasn't his. He later died intestate. The mother moved to make him the sole heir, and that man's family filed a motion to set that aside because they were like, that's not his kid.
He died
Without a will. Sorry. My apologies. I'm kind of, yes. Intestate means died without a will. So she moved to have her son, who was where the decedent was the legal father, but not the biological father. And so in that opinion, it was a 2014 opinion, and Judge Boggs at the time really let his feelings be known about administrative legitimation. But those are some of the issues that came about. And those are some of the issues that I think the subcommittee, when it was formed, set out to address. So then in 2008, that's when you actually see this voluntary acknowledgement of legitimation statute in play, when that is the 19.7.21.1, which has been repealed in its entirety in 2016. I can't find any cases I haven't found any cases where legitimation was an issue under that code section. All of it was under the previous code section. And an aside, another issue that was raised was, by putting that statement on a voluntary acknowledgement of paternity, there really wasn't much of a discussion regarding the rights, responsibilities, and implications of signing that. So that was another issue that they raised, that it was just this sentence or statement on acknowledgement of paternity without any real guidance regarding like what it all means. And then in 2016, you have the complete repeal. And before 2016, I mentioned that there was a subcommittee that was created under the Commission of Child Support that looked at administrative legitimation. And they formed some opinions, and it was in those records that I saw the first mention of just repeal in its entirety. And after it went out, from what I understand, to the community and child welfare legal law specialists, CWLSs, it seems like that was the decision to seek repeal. So also in that repeal, what you also see now is a legal definition of a father, of a legal father and the biological father. Before, those weren't in that code section. And then going back to that 1997 law, we see that they repeal the phrasing visitation privileges. So now they're taking visitation privileges away from paternity where it was housed already. So that kind of raises questions, at least for me, in respect to how the 2005 law came to be, if paternity and visitation were already somewhat linked because of this 1997 law. We've already seen this a couple times, but why this matters is because right now, almost half of children in Georgia are born to unwed mothers. And as Mr. Braswell said, we don't know how many of those children are not legitimated.
Is it possible that it was on the books, but it was not being executed just because of what Mr. Braswell said earlier? There's no entity enforcing it. Is that possible?
I don't know if it's necessarily that there wasn't an entity enforcing it. More so, it may have been an interpretation issue. I haven't come across any cases in my research regarding it, period. So I don't know if maybe it was successful and there was just never any appeals, thus no appellate case law for me to look at. And it was actually successful in like the district court
But you're comfortable that you're interpreting it correct?
Yeah, and yes, and the reason why I say that is because what we see across the country is after Perora, states are amending their laws to look like that. So it seems like Georgia followed the national trend at that time, because Perora was urging states to make these non-judicial methods of linking paternity or acknowledging paternity. And I say paternity and parentage kind of synonymously because when you look at federal guidance now, they use the term synonymously.
No, I was just talking to Katie about the fact that again goes back to our legitimation statute being an outlier. Yes, all the other states were going to an administrative paternity aspect, and that created rights. And we had a different system with a best interest standard. It did not shoehorn into that when it was then translated to the legitimation statute.
Well, I'm delighted. We've got so many really smart people involved, and special. Please thank Professor Carter, Melissa Carter, for us as well. She's been a great resource, as have you. And when we look forward to going way deeper, I'm very energized by what's happening so far, because at first it was such a complex issue, but there are certainly some themes that are bubbling up to the top that I think that will help us train our eye and our focus on going forward. At this time, if we'd like to go ahead and hear from some of the other folks in the room who have joined us today for the public comment section. And we've got a few folks here that we'd like to bring up if we can. Is Mr. Roberts in the room?
Mr. Chair, I'm sorry. I just noticed that Professor there had 2 more slides. Can you sum those up in about 30 seconds? Because I didn't want to just completely cut you off.
Yeah, no. So quickly, like we acknowledge that, having a legally recognized parent-child relationship benefits the child. So when we're looking at best interest, I wanted to highlight some of these things, like it boosts self-esteem, creates a family identity, expands benefits, things of that nature. And then for the direction of reform, it was the Uniform Parentage Act. So what happened is that in the 60s and 70s, the U.S. Supreme Court had a series of cases that addressed issues of legitimacy in children, and the court essentially ruled that treating illegitimate children differently from their legitimate counterparts was unconstitutional. So what happened was that the Uniform Law Commission created the Uniform Parentage Act of 1973, and it's gone through a couple of iterations since then. But what it does is that it looks towards, or it gives guidance on how to have these non-judicial acknowledgements of paternity or parentage now is what they use. And so in 2017 is the most updated version. And that one does a couple things because of some Supreme Court cases, the precedent. So it recognizes marriage equality and assisted reproductive therapy. And again, 26 states right now have adopted the UPA in some form, and almost all states have at least taken pieces from it. And SB 135 from the 2023-2024 session in Georgia acknowledged the evidentiary medical genetic testing of paternity in the UPA. So we brought in a piece of the UPA into Georgia's statute. And then, as I said before, all 49 states have non-judicial acknowledgements as a means to establish parentage and all those rights and responsibilities that attach to it. That was
In
it.
the other 49 states,
All 49 states have that.
including Hawaii and Alaska.
Yes.
Okay.
I'm sorry. Yes. No, it's yeah. Georgia is the outlier. Georgia is 100% the only state that has this two.
Did that happen during COVID or something? Like how did we miss the ball like that? Like,
How did you miss the ball like that?
Yeah.
I mean, that happened way before COVID.
okay, I was trying to give somebody some
Sorry.
excuse. All right. Well, I would like to see more on that. Can you provide us some more information on those states and what, in your opinion, at least the top 5, as Chairman Smith said, it's sometimes easier for us to look at other examples from other states and decipher that way. So if you can provide us like your top 5 favorite, I would love to hear that from your perspective.
So,
And this was an amazing presentation, by the way.
yeah, would you also like examples of other states' acknowledgements and how they because
Like anything you think would help.
perfect.
Yeah, we're
Listen.
trying to get to what is the gold standard? How do we, whether it's incremental, whether it's a top to bottom reboot, there's some very obvious things that have bubbled up today for me. And so best practices, we certainly value your opinions, and it's a lot of information to unpack today in a short meeting, but certainly value your very strong thoughts of, if I were rewriting the law myself, this is exactly where I'd go. I'd love to hear your thoughts on
Oh,
it.
yeah, do you?
And if you think these guys get it exactly right, and this would really enhance how we do things in Georgia. Ms. Quick, your background, obviously, as a former member of this House of Representatives, is uniquely interesting to me, and that you understand how the process works as well as we do. So look forward to hearing your very strong recommendations and continuing the conversation with y'all. Y'all have all been so helpful.
You know, I thought Miss Quick sounded pretty sharp. She's had some training in the well, huh? Okay, that's what it was.
The gentleman knows of what he speaks.
I'd like to just ask a general question. Mr. Braswell made a very poignant point when he said that one of the perspectives that had not been heard in the room today was from fathers who've been affected by this process. And just by a show of hands, I just want to see if those individuals that are in the room, how many people feel like the process is biased?
I have a sneaky suspicion that's a lot of hands. I have a sneaky suspicion some of them are on this piece of paper, and we're going to get to hear from them.
Thank you for that poll. Thank you. That was all I wanted to ask.
That was a great visual aid, by the way. Thank you for that, Representative. Mr. Roberts, Marcus Roberts, would you come to the mic and tell us what you're thinking? Yeah, we're going to try to help everyone get out of here at 1:00. So if we can, let's try and sort of keep it to 2 or 3 minutes.
Okay. So I filed for legitimization in August of last year. I was engaged, high school sweetheart. We lived together. We had a bad breakup. Keep it brief, but summarize everything. We had a bad argument. She doesn't come home with the children for about 2 days. I didn't really know what to do. As I said, we lived together multiple years. We're engaged. I drop the kids off, pick them up. during this 2 days of not seeing my kids, someone gave me the idea to like, don't you normally pick them up and take them to school? Just go pick them up and bring them home. I'm like, wow, that was a pretty, no brainer. I go get the kids, I go home. Not even 20, 30 minutes of me being at home, the police are at the door. I'm shocked because I'm like, what's going on? Y'all at the wrong house. I tell them what happened, or they tell me what happened from the call. And I'm like, wow, yeah, I picked them up, but that's a normal thing. So they then tell me, hey, well, the mom didn't appreciate you doing that. You guys are having some type of discrepancy, so she wants to come get the kids. And I'm like, well, we live together in this house, so where is she going to, take the kids if they're supposed to be here? To that standpoint, they let me know, well, wherever she takes the kids, that's her right to do so. And I'm like, well, even if I'm opposing that, her taking the kids from the house is not something that I agree with, they then let me know, hey, that's not up to you nor us. So we can't stop her, neither can you. If she chooses to leave them here or take them, that's on her. Cool. I let that happen. It was very emotional. That happened. Later down the line, I had to be removed basically in order for her to obtain legal access to the house without the discrepancy or whatever. So I leave, I'm removed. The officer at the scene, he saw how emotional I was, so he then tells me to get legitimized. I knew nothing about legitimization. My kids at the time were 5 and 4. I'd been in their lives the entire time, was at both births. Don't miss a program, nothing, doctor's appointment, dentist, I'm there. So I'm like, all right, legitimization should be simple. I go to the courthouse to file for legitimization. It's a $200 process. It's another $50 to pay to get the sheriff to go serve the what's it called? Basically just serve the person. So that's about 200. It was roughly about 270 altogether. I did it. Not knowingly at the time that I filed for legitimization that in order to take a father off of visitation in the state of Georgia, you have to file for a temporary restraining order. So now I can't pick the children up from school anymore. So now as I'm going through the legitimization, they present me with, hey, you have this order in place. So I'm like, okay, what do I need to do from that standpoint? So from that standpoint, now I have 2 court dates because I have to answer to the order and now I have to answer to the legitimization, which I do. Like I said, I filed in August. When they put you on the order, they state mandate you to family violence because of the order. I didn't know that, but I do that as well. I joined the class. I'm telling the facilitator what's going on, and he almost is in shock because he's like, "You guys didn't have an actual physical altercation. Nobody was, actually harmed. So we're, they were unsure why I was in the class, but I was in the class. So state mandated, so I still have to go through it, which was very it helped me a lot because I'm listening and watching other men go through this process that are volatile or violent or do have a lot of situations where, okay, I understand why these steps are put in place. So the facilitator is who actually forwarded me to Fathers Incorporated. He was like, hey, there's a program. You seem to need help with legitimization, so we're going to, forward you here. So I signed up voluntarily for Fathers Incorporated, and I did my family violence and Fathers Incorporated simultaneously. I finished both. The cohort, I started my cohort in January. As I started the cohort, I had my first legitimization hearing off the dribble, and to make it clear, I have 3 children. One's 14 from a previous relationship. The second set is from this current situation. So basically, when I get to the hearing, I'm opposing. Hey, with my first child, I have 1 week on, 1 week off, which gives the mother and I both even time to access to the kids. So I proposed that to the judge. The mom denies it. He said, okay, well, can I get them every weekend? The mom denies it. Okay, so the mom's like, well, I'm only comfortable with him getting them every other weekend, and which was a shocker. I'm like, you're gonna remove me from the home, which is okay. I understand in certain circumstances that's applicable. I did that. Okay. But now to affect the children that have seen me every day their whole life, now I'm subjected to only being able to see them, what, 7 days out of the month, or whenever she's busy or grants me enough time to do so. So again, I'm pleading with the judge, hey, I've never missed anything. I'm just trying to be involved, you know? The judge granted me visitation on the weekends, which was every other weekend. So I guess that put me about 8 days out of the month. And as I played, I'm like, hey, I'm only really asking for 14 to 15 days. The judge, the mom is in court agreeing, hey, he's a great father. He's a great dad. He's always there. He's this, that, and the third. But I'm not okay with granting him legitimization. The judge is baffled. She's taken aback. She's like, well, ma'am, are these his children? She's like, yeah, they're his kids. And the judge is like, so what are we doing about legitimization? And she's like, well, we have an order in place right now. So we're going to use the order right now to deny the legitimization until the end. I have never even heard someone actually being, as we've been using biologically, the father being denied access or custody to your children without anything actually happening. So when I joined Fathers Incorporated, a lot of brothers just gave me a lot of knowledge and access to resources. So I'm here today because I'm a millennial. A lot of people or men my age don't know about Fathers Incorporated, don't know how to get legitimated, don't know. And like people were speaking before, it's discouraging because you've seen thousands of men go before, or even men like me. I'm one of the first men in my demographic area to have a child, you know? So a lot of people come to me like, hey, what do I do for this? What do I do for that? How do I do this? So for them to see a guy like me have to fight for custody, it's extremely discouraging.
Well, we appreciate you for sharing your story today. I really thank you. It's difficult to stand up there and tell people about your personal life.
Yeah.
You know, but we know you're doing it for the greater good. I do have a few questions for you, and just yes and no responses will be great with me. So were you there when both of your children were born?
Yes, sir.
Did you sign the birth certificates?
Yes, sir.
Did you think that meant something when you signed those
I
birth
thought that
certificates?
was everything.
So if Georgia had a process that would have made you the legitimate father of those children at the moment that the birth happened, maybe a couple days, whatever that process may have looked like, would you have participated in that process?
Yes.
All right. Thank you, sir.
Thank you, Mr. Roberts. Mrs. Lockhart, Michelle Lockhart.
Hi. Well, good afternoon. I am Michelle Lockhart. Well, call myself a subject matter expert in legitimation. My CEO, Nick Fury from Marvel, gave me those wings, okay? To give you an idea of what I do on a day-to-day basis. You know, like in the court, you might have like the district attorney, the prosecutor, and then you might have the domestic violence like advocates. Okay. I'm the legal advocate for the dads going through the legitimation process. So I have to walk with those dads every single step of the way. So I get phone calls when they get to the steps to file and they get cold feet, they call me. When they leave the legitimation workshop, they're like, Miss Michelle, I don't know how I feel about this. I'm afraid. These dads are afraid to go through this process. Okay. And it doesn't matter if they make $100,000 a year or they make $30,000 a year. These dads are simply afraid to go through the process because although you can do the waiving, you can do like a purpose affidavit and have your legal fees waived. What if you can't find the child's mother? Then you have to pay for a private investigator. You have to get a process server. skip tracer or something like that. In situations where you have to go through mediation, and depending on which county you're in, the county will pay for like the first hour or two, but then after that, the father and the mother has to foot that bill. So while they say, how can we make this process easier? Let's talk about the parents. We're going to start with the parents who the mother and father are still together. They're best friends. They live together. They have intentions on getting married. We should streamline the process for them because they want to be together. They want this thing to work. But I've had cases where they'll go to court and the judge will say, I need a child support addendum. Well, the mother is there in court with the father and she's saying, we don't need that. We're good. He takes care of his kid. We're together. Like, what's the deal for that? And the judge will say, because I know it's at the judge's discretion, the judge will say, well, I don't know if you guys are going to be together for a long time. So I feel like we should go ahead and put this order in place. Okay. Now, that particular case, the judge wound up going to another district or whatever, and another judge took over and said, you know what, I'm not going to adhere to what that judge was about to do. I'm going to go ahead and go with what the mother said she wanted to, go with what the mother and the father said they wanted to do, which is not address child support. Because when you do that, it can put a strain on the relationship when you two are together. So that could be another discouraging factor when you have the mothers consenting to legitimation. I work with mothers and fathers. So that's the other unique thing about Fathers Incorporated. We work with fathers and the mothers in the legitimation process. And what I can tell you is when I do the co-parenting workshops and the mothers and the fathers are still together, the mothers are so shocked at like what the fathers have to go through just to be recognized as the legal father, right? And I'm gonna say keep it to 2 or 3 minutes. I wish I had gone sooner because I had a whole dissertation written down in my phone. Okay, so we're gonna stop it there and see if you guys have any questions.
A statement. We have 6 more months to work with you on.
Okay, all right. So that's all I say with respect to y'all's time.
If you want to come back and share some more details, you can travel with us.
I'll be there. He knows I'll be there. All right.
Thank you. Mr. Foreman.
First, I want to thank you all for even, kind of formulating this opportunity because this is some very important work. So I'm Javin Foreman. I'm the project director at Fathers Incorporated Gentle Warriors Academy. So I want to kind of let you know how we even got to the place to learn about legitimation. So you all being lawmakers, you all understand law, legalese, and that sort of thing. So as fathers started coming to our space in 2020 when we got this grant, our first mission and the only thing we were really required to do was to teach a curriculum that we had. But as we met these fathers, 3 things kept coming up. They needed assistance with child support, parenting time, and this thing called legitimation, which we had no clue what it was. Kenneth kind of grabbed the staff together. We went out on a retreat and we took about a whole week and we studied legitimation. We had presentations from attorneys that he had captured on video, and we had to dig in. So this is what I'm wondering, where were all these great people when we were trying to learn, right? But we had to do it. So it would come, fathers would come to us, and what they would say when we knew they needed legitimation? She won't let me see my child. That was the buzzword. Oh, you need assistance with legitimation. You might have a guy that moves here from Philadelphia, or we might talk to a father who's calling from Augusta, although we only serve Metro Atlanta. She won't let me see my child. We can't turn that dad away, even though we only have paperwork to help dads in Metro Atlanta. So we would go through the process and take them through our cohorts and that sort of thing. But I think one thing that hasn't been mentioned is, and the lawyers could probably speak to this, you can pay child support without having legitimation. And that's what really frustrates these fathers. What do you mean? I'm paying child support. I've even taken a DNA test to prove it's my child. What do you mean I don't have any rights? I said, sir, you have less rights than I do. As a guy walking off the street as the project director, only because I understand something about legitimation and you don't. I could beat you to the courthouse essentially, and I could legitimate your child because you don't know anything about it. So I think there are opportunities, there are great things I've heard. I've learned a lot, taking notes, but I think there are a lot of opportunities. So as we go through this 6 months, we'd love to ride along with you all to continue to learn ourselves, but also bring these stories that we have from the ground. So I just really want to be brief and thank you all for this.
Thank you for that. Justin Sosby, National Parents Organization.
Yes, good afternoon. First, thank you for doing this committee. And thank you for looking into this issue. This one it hits deep. My daughter's about 6 years old, and I wasn't married to the mother. And those are the worst times of my life that I ever experienced, and that'll probably be the same for probably all these other fathers as well. Yeah, I wasn't married to the mother. I signed the birth certificate, did the DNA test, and little did I know that didn't mean anything until you went through the court system. Which I filed for legitimation, had to serve my daughter's mom. Then the relationship got even worse. And if I know I only have a few minutes, but if I could probably have y'all watch a movie, it's a pretty relevant movie. It's called Marriage Story. I think it's on Netflix. But basically, it will show how adversarial the court system will turn between the mother and the father. Something as easy as just seeing your kid becomes the most complicated thing in the world. And it depends upon your relationship with the mother and stuff like that. But there was the first 8 months of the process, I never saw my daughter. Had to pay an attorney 3 times the amount of what I even make, $300 to $400 an hour. I mean, I would say I'm even fortunate in the income that I do make, and I'm like, there's no way that I could even keep up with this process. It's either that or I'm gonna go live on the street before I even see my kid. This shouldn't be like this. I mean, it shouldn't be as complicated as it should be. There's a lot of room for opportunity. And I think Georgia, has a big chance to lead the way. And this is not just a Georgia issue, this is a national issue. And I think there's a big opportunity to kind of set the tone of if we want to have both parents, which is beneficial for the child, to be in the kid's life. I think that would be the best thing for the kid ultimately. Even when I didn't have rights to my daughter, I was still giving voluntary, I don't know if you call it child support, because even if I didn't have legitimation or anything like that, there was no order for me to even pay anything to the mother. So that's even, it's not advantageous to the mother. It's not advantageous to the father, and especially not for the kid as well. But it's just, I would recommend seeing the movie. It's not exactly the same when it comes to legitimation. It's just like going through the divorce or legitimation process and kind of like what it does to a family. And it's the most realistic movie I've ever seen. And the funny thing is that the movie came out as soon as I started my thing and my sister, which she's a big support system. And I would say that like the women in my family have been the strongest for me and been the most willful in understanding what it's like to go through this process. So I want to thank all the good mothers and all the sisters and everyone that is there for their little brothers and for their sons and just being there for them. This is not only like a hard thing on the father and the kids, but it's also a hard thing on the families. So I think if, as you said, like Rome is not built over in a day, I think any step would be I think anything at this point would probably be a step in the right direction, because the way that it's going, it's, again, I would say I'm pretty fortunate with my living standards, but I'm like, if I didn't have this, I mean, you're almost like you don't even have, I mean, you can almost say that your rights are terminated without even going through a process. And I would say I know that I mentioned about in the situations of rape and stuff like that. Yeah, those cases I'm sure do happen. I mean, this is life. Many things can happen. But also, we also have a criminal justice system as well that takes care of those cases. And we have juvenile courts as well that deals with the very, very bad situations. But we still have a process if you're the biological father and you voluntarily sign the birth certificate and you establish paternity through a DNA test. I think the process should be pretty straightforward. And I'm not saying it's going to be perfect by any means, but again, like I said, I think there's a lot of opportunity for improvement. And I just want to say this, I want to thank y'all for taking the time to listen to all of us. This is, again, as someone else said, it's a human issue. I mean, I would say, like, if you're not going to do it for the fathers, I would say just do it for the kids at least, you know. They're the ones that really don't have a voice. They're the ones not standing up here. And I wouldn't want them standing up here like in the sort of, you know, having to like fight for this, but you know, I know that there's great mothers out there, and I know there's great fathers out here that want to have this voice, but they've just been so disenfranchised from having a voice. And you know, I want to thank everyone as well. It takes a lot of courage to do this, and it takes a lot of courage from y'all to do this as well. So I thank you again. I hope to speak to you soon.
Mr. Sosaby, before you take your seat, thank you for your remarks today. I think you and Mr. Roberts both speaking from a father's perspective. If no one in this room felt your emotions, they must be emotionless, because I don't think that fathers get the benefit of folks understanding the impact that this has on them too, especially men that are trying to be a father to a child and be that difference maker. And you know, you talked about your daughter, right? And I have an 8-year-old daughter, and I can just only imagine how I would feel if someone took her away from me for 8 months. We just got back from Disney last week, making family memories, you know, taking pictures with Minnie Mouse, and that because time passes and you don't get time back.
Exactly.
And there are great men like yourself out there, and Mr. Roberts and Mr. Braswell and so many other that just simply want fathers to be a part of their children's life and have the legal rights that a parent deserves. Not one parent over the other, but if you help bring this child into this world, and God blessed you too with that baby, it is meant for both of you to help guide that child until that child is an adult. And if you 15 seconds, if you could just articulate a little bit for us, what was that 8 months like for you after you filed the petition and you were being denied access to your child and you couldn't see your daughter?
I mean, thank God I have a supportive parents, family support system. If I didn't have that, I don't know, like it was hard to keep my job. Thankfully, I was able to do that. If I didn't have that, then I don't know how I would even do anything. Like I wouldn't know how to keep a place, like keep my apartment at the time that I had. I was the saddest. I feel like I hit the rock bottom, in other words. And you know, it's not like I had to pay my attorney, like I had to pay a GAL, and it was like I felt like I had to run through hoops just to prove that I was a decent human being. And I'm like, again, I'm paying like GAL $200 an hour, then I'm paying my attorney like $350 an hour. And you know, to be clear, at that time I was making 75,000. So I mean, it's unsustainable. Like, and so at some point, you know, either you give up and then the kid doesn't have a father, and you know, and the thing is too, it's the mothers that have to pay up too. I mean, it's not like just the fathers are paying all these attorneys fees as well. I mean, I would say this, why would it, and I went through the uncontested thing, that it was referred to as uncontested legitimation, but I don't understand why would it be contested if I was already like did the paternity test. What is there to contest? Unless I had like a criminal background, which I don't. Unless there was something so significant that was like, why is it so hard? What are we contesting at that point? I'm not understanding the whole, I still don't understand it. And I think the thing that you know, as my sister rightly said a long time ago, she was like, and I was like, I'm just trying to get some parenting time, like at least something, at least trying to establish I have legal rights to my kid. She's like, you're trying to make sense of a system that doesn't make any sense. And it's just, I mean, I'll just say this, I hope that no one in your family or yourselves or anything like go through this, because once you see someone that goes through it, it's the most traumatizing thing that you'll see. And I hope that, again, like I just want to see like some progress made. And I think there's a lot of great ideas and stuff. And, you know, again, I think we're there's just so much for improvement. And again, I know that we're in the very beginning of this stuff, but I want to look, I would love to work with y'all and, seeing what those solutions are. I don't have all the solutions. I know there's other states that are working on, like Florida. I think they've done something pretty good, I think, in 2023 as far as establishing paternity legitimation and stuff. So, but anyways, we can discuss that at a later time. But
Perfect.
y'all have been great. I appreciate all y'all's time. Y'all are amazing. Okay.
Thank you.
Thank you so much.
Representative Hefner?
Yes,
I'm sorry, I didn't.
I just want to say thank you, sir, very much for sharing. This gentleman who came before you and earlier, and the people who speak to this organization. Thank you all so very much. And just on behalf of my colleagues in this body, it is almost embarrassing to hear these stories and know that we're a part of a system that embellishes that process. And just speaking for myself, I'm committed to a process that will help ease that. And I'm sure it does not offer you, either of you, any solace. But please know that your voices are heard. If we can't wave a magic wand and fix this, it is certainly not due to a regard that we don't care. There is a sincere spirit here that wants to bring some light to what you so eloquently said is unsustainable. It's mind-blowing. But thank you very much for sharing your experiences. I know it's difficult to be transparent, but if you will continue with us in this process, I assure you that the individuals that I speak with here, that I sit with on this committee, we are all committed to a process that will help.
Thank you.
And thank you once again, all of you, for your time here today. Thank you.
Thank you. Great thoughts. I'd like to ask you, you subject matter experts, if you would like to close us out with a last minute thought, just to wrap it up. We could talk to each and every one of you for 2 days each and still have a lot of ground to cover, but love to hear your sort of final thoughts if you'd like to.
I see some.
Yeah, Mr. Chairman, thank you for the opportunity to just tag along with Katie Cannell. And I certainly am available to anyone who wants to talk about how to make this situation more equitable for non-custodial parents that are paying child support. Because there really needs to be some relief there. And I'm committed to whatever time the committee wants to spend doing that. I think there are some outlines that have been worked on over the past 2 or 3 years, some thoughts, and we can do that offline, online, however y'all would like to do it. But thank you for the opportunity to show up today unannounced and listen in.
Thank you. Mrs. Putt.
Yes, I just want to thank the committee for the invite. Anytime that practitioners have the opportunity to sort of provide some input into how we think things could be improved, at least to make it easier on ourselves and for our clients, because we always want to do what's best for our clients. We relish the opportunity to do that and make these things a little bit easier. Because much like the fathers that were here, the hardest thing is having a client call in and say, the relationship ended. I just want to see my kid. And explaining this process to these fathers and how onerous it is on them just to see the basic time is really difficult. So anything that can help improve that for both us and our clients will make things easier as well. Thank you.
Thank you.
On behalf of the Barton Center, we are happy to provide any and all resources and research and partnership that we can offer in addressing this really complicated issue. Especially because, the way that the structure works now in respect to being financially responsible, but not having any of the parentage that comes along with it, really sends the message that the only thing a father can really contribute is financial. And it really ignores the the security and the emotional attachment that fatherhood can.
Thank you. Thank you.
I just want to say thank you all for allowing us to come into this space and to speak about our experiences from a practitioner standpoint, for being able to listen to the fathers. I didn't think this conversation would start this soon, but I'm glad to see this committee has come together to start having a conversation about how we can, sort of fix this whole legitimation thing. And I want to give a special thanks to the fathers, especially like the ones I work with. They give me the energy to keep going and to advocate for them in the process. And like you said, if you can't feel what these fathers go through, like you don't have a heart. And but we can't do the work we do without hearing from the fathers and them allowing me to work with you on these sensitive matters as a woman in this space. I just want to say thank you. And I look forward to seeing what is going to become of this committee. I feel like we're going to make good trouble. And I just want to say I'm open to being more instrumental without a 2 or 3 minute
Okay. Mr. Braswell, you'll get the second to last word.
And I just want to thank you as well. This has been overwhelming. I, like Michelle, for years, people have said to me, you need to press this legitimation issue. And I'm like, no, we got to wait. It's not time. It's not time. We really need to build proof of concept. It's been the work of Fathers Incorporated to make sure that when we got to this stage, that we would clearly understand what it looks like from a father's perspective. Because we believe that that voice needs to be forefront and in the center of this work. I will also add one more suggestion. Keith said it, or Javin, someone in the back said it as we were talking about another voice that needs to be brought into the space, and that is the voices of the judiciary system. Judges. There are several judges that we work specifically with that speak from this same space across the state, and also lend perspective to this conversation from the bench, which is really a different bird's eye view when they're looking at it.
We have judges scheduled for Columbus.
And that was the last thing. We will be in Columbus and Augusta. So
Good,
whatever
good.
you need from us, let us
Excellent.
know.
Well, I'm humbled at the fantastic turnout today. Ms. Connell, you were the first cornerstone on which these conversations started. So thank you for your constant involvement, and all of you. Yeah, the Barton Center, y'all are just so much information and such smart people. The committee members, we couldn't have a better committee to carry the ball on this. I couldn't be more excited about who I get to serve with on this. And it's a truly bipartisan issue, and we are absolutely committed to making real progress, not just making noise, but making progress and moving the ball forward on this. The Speaker of the House, he doesn't just willy-nilly call for study committees. There's a lot of thought that goes into these things, and his commitment to the process is very exciting. I think it was almost serendipitous today, the way that we had the prayer vigil at the Capitol in the middle of this meeting, and it was fun that we could all go there, and the speaker was there as well. Our vice chairman is just as passionate as anybody in this legislature, and Representative Hefner is a great dear friend of mine, and we're very fortunate. I'm very fortunate to get to serve with them. But we're just so grateful for you. We'll see you in Columbus. We'll see you in Augusta. And we'll see you at the top as we make progress on this issue. Thank you.
What do you need from
I'm sorry, we're adjourned.